We now call cause number 23-41591, the state of Texas versus, God bless you.
This case starts like a routine plea hearing, but don't blink. What you're about to hear involves a third-degree felony assault on a pregnant woman, a deferred probation deal, and a judge who is clearly holding back until the full facts come out. At first glance, this looks like paperwork and procedure, but as the probable cause affidavit is read, the tone of this courtroom shifts fast. The question is simple: when violence crosses this line, is probation enough, or does accountability demand more? Stay with us, because this hearing takes a sharp and unsettling turn.
Not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
This one.
Agreement has been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? What do you say?
Guilty.
Okay. Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence
Objection.
without objection admitted without adverse intervention possession. How long was he in jail?
Thanks. Judge, he's Mr. Francois saying he was in jail for 5 months.
Among other things, this states Exhibit 1 that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
Stand up.
A record showing he was in custody for 153 days on the
That's what she says. Yeah, that's what it's showing. Y'all are working off the same page. That's great. Anything further on this?
No.
I'm going to make the findings that, and again, you are pleading guilty today voluntarily and because you are guilty.
Sir.
All right. I'm going to make findings based upon State's Exhibit 1 here that's been signed. That this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And you are guilty of this crime and any lesser included offenses. I am going to find, indeed, you are mentally competent to enter this guilty plea. It is freely and voluntarily made, even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt, follow this agreement, and place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it can be shortened to 30. There will be terms and conditions of probation which are focused on this type of case.
I need to interrupt you on,
Okay.
On these type of matters. This is an area in which the court cannot reduce the amount of time for on the probation on domestic violence related.
I know, I'm going to place him on 10 years deferred or unadjudicated probation.
You made the statement that you, if he did well, you could reduce it by a third.
Okay.
The law says that you cannot.
I'm sorry.
Yes.
Judge,
Yeah.
we also discussed a 5-year defer.
And that's one of the reasons why I agreed to 5 years in that. And I hate to interrupt the court, but that's the reason why I interrupted the court.
Okay, this Family Violence Act.
Yes, sir. So I'm asking that you approve the 5 years, Judge.
All right, then the court will, and that's agreed upon. by the defense. I'm going to follow this recommendation of both parties, and you will be placed on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. The court is looking at this probable cause affidavit, which is most disturbing. You're with me? This is for you.
Yes, sir.
This probable cause affidavit is most disturbing. This, the victim here was 5 months pregnant with your child. She was taking a shower when you went over to her house, punched her in the stomach. The pregnant lady punched her in the stomach. She was nude. She was unable really to be able to defend herself, put in a bad spot. She says you also picked up a kitchen knife and stated you would kill her. You broke her phone. Police were called. They had visible injuries to her face, scratches on her chin, swollen side of her face. You fled, of course, before the police could arrive. And then, since the incident had occurred, according to the probable cause affidavit, you subsequently called her threatening violent acts. What else could you have done wrong? I can't imagine really a more selfish act could be done than punching a pregnant woman in the stomach. Shame on him. Mr. Man, Mr. Gentleman. And it's your child, right?
Yes, sir.
Punching the mother of your child's stomach, 5 months pregnant. Well, it's about as low as it can get. You've got 153 days. I can sentence you up to 180 days as a condition of probation, and you're going to get all of that. You've still got 27 days to go. You're going to go back to jail. You're going to get every minute of jail that you can. Don't look at him, look at me. I can sentence you as a term of probation to 180 days. You have 153 days credit. You're going to do 27 more. To the last second for this. Yeah.
If I may, Mr. Francois has seen the error of his ways, and he is currently enrolled.
How does he take back punching a pregnant woman in the stomach? And he's seen the error of his ways. He has. How long did that take? I mean, I don't mean to be facetious, but this is clear to everybody on this planet that this is wrong. And I couldn't care less the way you think about this. Really? What are you upset about? That you're being held accountable to assaulting a pregnant woman? This upsets you? You find something unfair about this? Speak. Do you? Or do you think this is atonement for what a terrible error you did? Or am I putting words in your mouth? Because I don't hear much regret.
Your Honor, I'm not saying anything I did was right.
Okay. All right. So,
I
yeah, go ahead.
yes, I have made changes in my life.
How do you take back punching a pregnant woman in the stomach? And
I
what kind of harm can that do to a fetus?
can't.
Immeasurable. No, you can't. But
I-
you can, by your actions, do better. You can also, by the terms and conditions of probation that I'm going to set, be an example for others that this is not acceptable. You're going to talk to him while I'm speaking to you? Is this boring you?
No, sir.
What?
Judge, if I might finish.
Go ahead.
He's been on bond for 2 years at this point, had no issues. He is currently enrolled in a welding certification process. He graduates next month. So putting him in prison right now, or in jail, thwarts his entire life. I understand what What I'm saying is at that point, you're setting.
You think I'm sorry for him? I feel sorry for the fetus and the pregnant lady who he punched at 5 years, at 5 months pregnant. That's who I'm feeling concerned about. Or am I missing the boat here, gentlemen?
You're not at all, Judge, but I will.
He's going to do 180 days and he still has 27 days. Do you work on weekends?
No, sir, only Monday through Friday.
Okay, then you can serve it on weekends so you can keep your work.
Okay.
You check in at 6, on or before 6 o'clock every Friday. You've got 27 days
Yes, sir.
to do it on successive weekends.
Yes, sir.
And you're going to begin this coming Friday.
Sir.
The
Thank you,
weekend after
Judge.
Thanksgiving,
Sir,
the weekend after Thanksgiving, this Friday.
this weekend.
Okay, just making sure I understood.
No, yeah, this weekend. I just,
It's being cool.
this is the kind of thing that's not even a question. This is clear that this is most serious and disturbing. And how you thought that this was going to solve any kind of relationship problem. It defies imagination of any reasonable person. And it wouldn't be, I wouldn't be doing my job if I didn't stand for something. And that is this kind of behavior deserved punishment. And I'm not going to be light on what I can do under these circumstances. I'm going to protect fetuses and pregnant ladies. I have a feeling that you regret what you did. I really do. But I wish you would have called me an hour before you went over and said, I'm about to do something foolish. Help me make the right choice, Judge. And I'd have helped you. Because this one is clear. This was a bad choice. And you're just lucky that is the child fine? Appears to be fine?
What we just witnessed is a courtroom drawing a hard moral and legal line. The defendant avoided a prison sentence through deferred adjudication. But make no mistake, the judge made it clear this was not mercy, it was conditional accountability. The facts laid out were disturbing. A pregnant victim, physical violence, threats with a knife, and attempts to flee responsibility. Deferred probation doesn't erase guilt, it puts the defendant one mistake away from a felony conviction and years behind bars. The judge's focus here wasn't sympathy for excuses, but protection of the unborn child and the victim, and that message could not have been clearer. Now, we want to hear from you. Did the court strike the right balance? Or should this have resulted in immediate prison time? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.